The SEC just issued another no-action letter for relief for state trust companies custodying digital assets. The SEC is beginning to align its custody framework with the digital assets industry practice. The SEC's Division of Investment Management has issued a no-action letter confirming that certain state chartered trust companies may serve as qualified custodians for digital assets and related cash equivalents under the Investment Advisors Act and the Investment Company Act. This means that registered investment advisors and funds can now custody crypto assets with eligible state trust companies, entities the SEC staff is now willing to treat as banks for custody purposes. This is huge because under the Advisors Act, custody rule and related provisions of the 1940 Act, client funds and securities must be maintained with a qualified custodian, generally defined as a bank or a broker-dealer. And until now, whether a state trust company could meet that definition was uncertain at best. This no-action relief resolves that question, at least for entities that meet rigorous operational oversight and reporting standards. The SEC letter conditions relief on extensive due diligence and investor protection safeguards, including 1, initial and annual assessments of the trust company's custodial capabilities, 2, policies reasonably designed to safeguard crypto assets, 3, audited financials and SOC 1 or equivalent controls, 4, full risk disclosure to clients, and 5, written custody agreements that prohibit rehypothecation and require segregation of client assets. The staff has emphasized that this relief is fact-specific, and a trust company that fails to meet these standards or materially changes its operations could lose eligibility. In reality, the industry has been moving in this direction for years. State chartered trust companies, especially those formed under frameworks like New York's Limited Purpose Trust Charter, have been performing bank-like custody functions for digital assets since at least 2018. These charters were originally designed to offer bank-like structures without requiring full depository licenses, and the model proved both more accessible for crypto firms and more attractive for states looking to bring digital asset business within their regulatory perimeter. The SEC's no-action relief effectively acknowledges that reality and legitimizes a structure that's already functioned responsibly under state oversight. So this represents an exciting moment for RIAs and funds and provides long-awaited clarity and an actionable path to compliant custody of crypto. Broker-dealers, however, remain kind of in regulatory limbo. The SEC has maintained that there's no legal prohibition on broker-dealers holding crypto, but in practice, none have yet cleared FINRA's approval process outside of the special purpose broker-dealer model. So broker-dealers will likely remain in a holding pattern for at least the next couple months until the SEC revisits the custody rule in upcoming rulemaking or issues another no-action letter. My name is Braeden Anderson. I'm a partner at Gesmer Updegrove. Thank you for watching. Stay tuned for more updates on the intersection of securities law and digital assets.